Side presiding.
Please be seated. Are we on? We are on the record this morning in the matter of Winter versus Dillard. Case number is 220902360. Let me have those that are appearing in the matter. Please note your appearances. Ma'am?
My name is Hope Winter.
Thank you, Ms. Winter.
Mr. Dillard is here as well, Your Honor.
So this is Mr. Carlos Dillard?
Yes, sir.
Thank you, sir. The record will reflect that the parties are present. We're set for an evidentiary hearing today on an objection to a stalking injunction. Are the parties ready to proceed?
Yes, Your Honor.
All right. Then the request for hearing was filed by Mr. Dillard, which was timely filed, that then requires Ms. Winter, you to go forward and make a showing sufficient to justify the stalking injunction. What I'm going to do in this case is have the clerk place both of you under oath, and then I will hear statements from both of you to include whatever evidence you can summarize. This is in the nature of a proffer of your evidence. You can make references to additional witnesses as long as those witnesses are present, and I will hear those proffers. If there is cross-examination that either party requires of anyone, including witnesses, that may be permitted as well. But I just need to make sure that that process and procedure will work for both of you. If you have documents, they should be marked so that there would be petitioner's exhibits and respondent's exhibits. The petitioner's exhibits from Ms. Winter would be designated as P1, P2, P3, the P being the petitioner. The respondent's exhibits should be appropriately designated as R1, R2, R3, etc. They should be marked that way before they are offered, just so that they are appropriately identified. And if, as you're making your presentation, if you identify any exhibits, please make sure that you identify them by whatever designation they've been given. So P1, P2, R1, R2, whatever that may be. And then I will, before I actually receive any exhibit, I'll ask whether there's objections to those exhibits and consider any objections before documents are actually received. Any questions on the procedures? Mr. Dillard?
Yes, Your Honor. From my understanding, the petitioner was supposed to supply any type of evidence or information that she was going to bring today. I have not received anything, nor am I aware of any evidence that she plans to show today. According to Utah state law, she was required to do that 14 days before we appeared here today, correct?
Well, this is a hearing on a stalking injunction. The requirement for the submission 14 days before the hearing applies generally on trials. Stalking injunctions are heard on an expedited matter, and so the rules with respect to the pretrial disclosures, the exchange of lists of witnesses and copies of exhibits, generally 28 days before trial, and then objections 14 days before trial, generally does not apply on stalking injunctions. If there are documents that are the subject of objection, for example, if there's a document that you're not familiar with, that could have reasonably been provided and has not been provided, that may be a basis for objecting to that document. Understood. And those objections are reserved on both sides.
Understood.
So I'm not making any ruling on the admissibility of any document until it actually becomes an issue.
Understood. Thank you so much for the
Okay. Any other questions?
One last question. As we're presenting our sides of our evidence, would I get the chance if she is saying, or if the petitioner is saying something that is untrue, I do get the chance to object to what she's saying in that moment, correct?
During the presentation of either party, if there is an objection, you certainly have a right to object. But objections are legal objections. Your disagreement with the statements is not a legal objection.
Understood.
So if a party says, I lived on Adams Avenue for 5 years, and you disagree with that fact, that disagreement is not a proper objection.
Understood.
There are proper objections, foundation objections, authentication objections, hearsay objections. There are numerous legal objections that are appropriate, and all of those are available. But your disagreement with a statement is not a legal objection and is not appropriate.
Understood.
You'll have an opportunity to provide your own testimony and your own evidence. It's not unusual in a trial for evidence to conflict. So the fact of disagreement is not a basis for objection. But certainly if there are legal objections, those legal objections can be raised by either party. Okay?
Thank you for that explanation, Your Honor.
All right. Ma'am, any questions that you may have regarding the proceedings today?
No, sir.
All right. Then I'm going to have both parties stand. I'll have the clerk place both of you under oath.
Do you and each of you solemnly swear that the testimony you shall give in this hearing now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Please be seated. Ms. Winter, what I'm going to ask in your initial presentations where you're summarizing your testimony, if you'd stand at the podium and you can address the court, but you need to stay close enough to a microphone that we have an accurate record of everything that's proceeding. So if you'd like to stand, and if you have documents that you believe are appropriate to be introduced, there should be enough so you have a copy you can provide to the court. Mr. Dillard should have a copy of any document. And again, before anything will actually be received, I'll consider any objections to any documents that are offered on either side. So you may proceed, Ms. Winter.
And before you receive them, Your Honor, will I get a chance to see them so I can know?
Yes, you need to have the same copies that I have. And what we have here, and so, ma'am, you provided me with a series of documents that are numbered and identified just by the word evidence number 1 through 7, correct?
Yes, sir.
All right. What I'm going to do is simply designate that the documents which bear those designations, evidence number 1, evidence number 2, evidence number 3, etc., through evidence number 7, are designated as the petitioner's exhibits and exhibit numbers, having been marked accordingly. So what we will do, and Mr. Dillard, do you now have copies of those 7 documents?
I do.
All right. So what we'll do, Ms. Winter, as you present your testimony, if you would like me to consider any of these documents, you need to then specifically say, I would like you to consider, or I move to admit evidence number 1, or evidence number 2, or evidence number 3. Before I will actually look at that document or review its substance, I'll determine whether there's any appropriate objection and whether if there is an objection, whether it can be admitted or not. And then, Mr. Dillard, when it comes your turn to present evidence, including documents, the process will be the same. Ms. Winter will have copies of whatever documents there may be, and if there are objections to their admission, those will be considered by the court. So you now have copies of the proposed exhibits?
Yes, sir, 1 through 7.
1 through 7.
Yes,
the court has in its possession copies of those documents. None have been admitted at this point, and I'll hear Ms. Winter's presentation and then consider any documents in connection with that presentation. So, Ms. Winter, if you would step to the podium, you may make your presentation.
Good morning. Around May 21st, 2022, my family was going through a situation that I spoke out about on social media. I had several videos go viral, all of which included me explaining what happened and asking for help or resources, anything that could point us in the direction of gaining more education for what is considered now a failed adoption. Mr. Dillard was tagged in a comment on one of these videos.
Ma'am, before you continue, presentation of evidence requires that evidence be from your personal knowledge and recollection. it is not appropriate to simply read a written statement because the court has no idea who may have prepared that statement or whether that is your actual knowledge or testimony. So I'm going to ask that you present your information from your own knowledge, not from a written statement. And you can identify, most importantly, dates, names, places, circumstances, but I will require that the presentation be made from your personal knowledge and not from a written statement, okay?
So,
you may proceed.
On May 25th, after I had been in contact with Mr. Dillard for one video, he had went on his TikTok, on his social media, and posted my minor sibling's address on...
Objection, Your Honor. That's hearsay.
And what is the basis of the hearsay objection?
She doesn't have any evidence that I posted that TikTok. Does she have?
I do have evidence.
Hold on. When an objection is raised, I hear the objection. Only one person speaks at a time. If you are making a statement and an objection is raised, you simply stop speaking.
Yes, sir.
Mr. Dillard can voice his objection. I may then engage with Mr. Dillard so I understand what the objection is. I may then ask you for a response, but please wait until I ask for that response. This is not an opportunity for the two parties to engage in a dispute between themselves.
Yes, sir.
The court is now in control of this discussion, and I will request information from either party when it's appropriate, and then make a ruling when that is appropriate. And I request that both parties simply respect the authority of the court and simply respond when asked to respond, and not to engage in a disputed discussion between yourselves, okay?
Understood, Your Honor.
So there is an objection. The objection is to hearsay. I want to understand what the statement is that's claimed to be hearsay.
The petitioner says that I made a video. I went on live on a TikTok video.
Okay, hold on. So that is the statement you're claiming is hearsay.
Yes.
That is overruled. That is not hearsay. Hearsay is defined as a statement made out of court by a declarant, and it is being used to establish the truth of the matter asserted. This is simply information being provided by a party as to her personal observations. Personal observations are not hearsay. Now, you may disagree with what she says, and again, your disagreement is not a legal objection. But she can testify as to whatever her perceptions are. And hearsay is a very specific, defined circumstance. Let me give you an example of what hearsay is so that parties understand. If, for example, the witness were testifying, and that testimony was that on May 15th, Mr. Dillard's neighbor contacted me and told me that Mr. Dillard was planning to invade my home, there would be a proper objection for hearsay. There's a declaration being made by a party out of court, and it's being offered to prove the truth of the matter asserted. That is, that some third party made a statement that Mr. Dillard was going to do something. Now, that is certainly subject to a proper hearsay objection. That is an example of hearsay. But when a hearsay objection is raised, I will be asking, what is the declaration? Who is the declarant? Who is the person that said whatever it is that you're objecting to? And for what purpose is it being offered? That way I can determine whether it's hearsay or not. But just disagreement with the statement is not a hearsay objection and will not be considered. And please proceed, Ms. Winter.
Because the safety of my siblings had been brought into play with the situation with Mr. Dillard, I had filed for my stalking injunction that day, and I listed them as being protected on the injunction. Once, on the same day as the address being released, I had called the police to report that, and while waiting for a phone call from the police, I received a blocked phone call from Mr. Dillard.
Objection, Your Honor. Cause for speculation.
I'll sustain the objection. Really is a foundation objection. Your testimony was that you received a blocked phone call from Mr. Dillard. What I really need to know is dates, times, and circumstances to determine what is the basis for your suggestion that that came from Mr. Dillard. So if your testimony is you received a phone call from a number, you recognized the number, it was a number that Mr. Dillard had used to communicate with you in the past, that kind of information gives me foundation.
Okay.
But just to jump to the conclusion is not appropriate, so the objection is sustained.
Okay.
But that's a foundation objection. You may proceed.
The injunction that I had filed was granted to me on May 26th. That was a Thursday, so on Friday I was told that I needed to give the injunction paperwork to the correct precinct.
To whom?
The correct precinct to serve the paperwork to Mr.
Okay.
Dillard. That Monday was a holiday, so when I received a phone call from an officer from King County, which is where I believed that Mr. Dillard resided, they said that Mr. Dillard, they stated he no longer lived in Washington, that he refused to give a forwarding address, and that Mr. Dillard stated that I would have to figure it out.
Your Honor, objection, hearsay.
I would like to...
Ma'am, your response?
I would like to put in evidence number 1.
All right. So you were in communication with the sheriff's office.
Yes.
And the communication had to do with the location of Mr. Dillard?
Yes, it did, for serving him with the injunction.
All right. And this injunction that you're talking about, is that a stalking injunction that was issued in this case?
Yes.
All right. So you spoke to the sheriff's office, and this discussion was about serving the stalking injunction?
Yes, about getting it to Mr. Dillard because he lived in another state.
And when did that occur?
So that was... I'm trying to figure that out. I'm sorry. They attempted to serve him on the 31st of May, and then I got the return of service on June 2nd.
All right. My question at this point is the relevance of this particular issue. If what you are seeking is to make that stalking injunction permanent, how it may have been served is not evidence as to whether it was valid when it was obtained. The more important question is there a valid basis for the stalking injunction?
No,
and that's what we're here to determine today.
Yes, I understand. I had received it was the motion to dismiss from Mr. Dillard, and he said that he was shocked to receive the injunction.
Objection, Your Honor, hearsay.
Hold on just a moment. So you had received the stalking injunction, and you were attempting to serve it on Mr. Dillard.
Yes.
And again, the important thing to me is why should you have received a stalking injunction? Those are the facts that I need to know.
All right, I understand.
What happened after you received the stalking injunction, whether it was difficult to serve Mr. Dillard or not, it really isn't the question we're here to decide. Mr. Dillard is here. He can speak for himself. He's obviously aware that it was obtained. He is defending it. He's requested the hearing opposing it. I need to know why it was issued so I can decide whether it was appropriate to issue it at all. And so that's the issue that I want to hear your testimony on. Because if I don't hear any evidence that there was a basis for issuing the stalking injunction, then it should not have issued, and the court will dissolve it. So that's what's important today, okay?
Okay. When filling out the form for the stalking injunction, I was asked if I had any information that would make a reasonable person feel emotionally distressed, afraid of being physically harmed, or afraid that someone else would be physically harmed. And I had stated that Mr. Dillard had a history of harassing women.
Objection, Your Honor, hearsay.
That's sustained. Again, you need to tell me specific dates, times, and places, events and circumstances that involve Mr. Dillard that would cause a reasonable person to be upset. Let me give you an example. A statement would begin something like this: on, and then fill in the blank with a date. I was contacted by Mr. Dillard, and Mr. Dillard said this. or Mr. Dillard did that, or someone else approached my house. I need to know what happened that justifies a stalking injunction.
Okay.
Not just general conclusions about your impressions from whatever may have happened. I need to know what happened.
Okay. I'm just trying to figure out my thoughts really fast. I apologize. So I started feeling unsafe after Mr. Dillard's first video on I believe it was May 21st or May 22nd.
Again, you need to back up, ma'am, in time. How did you even meet Mr. Dillard? How do you know Mr. Dillard even exists? I don't know anything right now. So for you to say, I became uncomfortable after, and then start talking about that doesn't help me at all.
Okay.
I need to know what this case is about, how you became aware of Mr. Dillard, what Mr. Dillard did, what you did, and why it justifies a stalking injunction.
Okay. I apologize.
No, you're and I understand. You're here without attorneys.
Yeah.
You're not trained in the law, and you're doing the best you can. So I'm trying to just help you understand what I need to hear,
okay,
so that the matter can proceed.
Okay. So on May 20th, I had posted on social media about a situation that went viral. We were attempting to adopt a baby, and
This is May of 2022.
2022, yes.
So you posted something on the internet.
On the internet, yes. And Mr. Dillard was tagged in one of the videos. We ended up going live.
Well, hold on just a second. So whatever you posted included some videos.
Yes.
Of something.
Yes.
What were the videos about?
They were me talking about what had happened with the adoption that has now been failed. It's a failed adoption. They were me just explaining what was going on and what happened, and it started getting some traction on the internet because it didn't sound like a situation that should have happened.
So you posted some videos
yes.
on the internet about your circumstance in connection with an adoption.
Yes.
And how did Mr. Dillard become involved in those videos?
Mr. Dillard claims to be a foster youth advocate.
Objection, Your Honor. Relevance.
Overruled.
He claims to be a foster youth advocate, and so he was tagged in the videos by people that were getting his videos, and then my videos showed up. So, like the algorithm. So he was tagged in those videos, and then he said he would be talking about it on his own social media page.
Objection, Your Honor. Foundation.
Sustained. Foundation objections go to the date, times, and places of circumstances.
Yes, sir.
So again, we're just in your mind, kind of picture using building blocks. Each building block is a little piece of information. Dates, times, places, circumstances are all important.
Okay.
So not just the conclusion, not just the end of the story. I need the story, not just the end of the story.
On May 21st, Mr. Dillard had invited me to it's a Go
Who
Live.
had invited you?
Mr. Dillard.
Okay.
He invited me to speak on his page regarding what was going on with our circumstances.
On his page, is that a Facebook account?
On his social media, his TikTok page.
Okay.
And I didn't know I was being recorded for future content use on his page.
Okay.
And hours later, after, this was May 21st,
Objection, Your Honor. Speculation on that last piece.
Overruled.
Hours later, he had started creating content with my videos and my questions and the questions that he asked. And around May 22nd and May 23rd, Mr. Dillard started not using my name, but calling me a sex trafficker and a human trafficker. And that's when...
Objection, Your Honor. Hearsay.
So what is the declaration that you're claiming is hearsay?
I never called her that.
What is the declaration you're claiming is hearsay? That needs to be a statement made by someone.
The declaration that the petitioner said that I called her.
So you're claiming that your own declaration, her characterization of your declaration is hearsay.
Yes.
Okay, that's overruled. By rule, the statement of a party opponent is by definition not hearsay. So you may proceed, ma'am.
So at that point, I deleted all of my social media. That was May 23rd, May 24th. My social media was completely wiped off. And I assumed that the videos from Mr. Dillard would stop, and they did not. May 25th was when he posted the address of my siblings. And
Say that again.
on May 25th is when he posted the address of my siblings.
Objection, Your Honor, hearsay.
What is the statement, sir?
Actually, I'm going to change that to speculation. Speculation.
I'll sustain the objection. It really goes to the form of the information. When you say he posted, ma'am, what he may have done may have been done by him. It may have been done by someone else entirely. I need to know what happened. So on such and such a day, you observed something, and that something caused you this or that or the other. I don't know. But again, I need more than just general presumptive kinds of information. I need to know what you saw. I need to know what you heard. I need to know what was said to you. But simply to state what somebody else did, who is, unless they're present and you're observing it, becomes very, very difficult. Your testimony as a fact witness includes whatever you have seen, heard, or sensed with any of your senses. What you may surmise, or what you may guess, or what you may think somebody else did, isn't your testimony. So tell me what you saw, what you heard, what you did, and what you observed, so that I can understand, again, what's going on here.
If the court would allow, I have a screen grab from his video with him in it and the address of my siblings on it.
Well, let's go first.
Okay.
You had offered this evidence number 1. Are you still offering that?
Evidence number 1 is no longer relevant for the time.
Okay, so we're not going to address evidence number 1. So is this one of the other documents that you intend to introduce?
It is not a document. It's a digital file that I have brought with a flash drive in my computer.
And it's not been copied in a format that I can look at other than displaying it somehow?
Correct.
Has it been provided to Mr. Dillard?
Unless he has it on his page, no.
Then I'm not going to permit it.
Yes, sir. So, again, May 26th is when my injunction was approved. And he was attempted to be served on May 31st, and I got the return of service June 2nd. After figuring out where Mr. Dillard resided, we ended up attempting to serve him again. That was June 23rd, I believe. And I would like to admit evidence number 4.
What is evidence number 4?
Evidence is a screen grab from his personal Instagram account saying that he was excited to get back to accept the serve.
Objection, Your Honor, relevance.
What is the relevance of this document, ma'am? And relevance is, in order for something to be relevant, it has to either help establish or contradict some matter that's important for my decision today.
I understand. In the motion to dismiss that I received from Mr. Dillard, again, he said that he was shocked that he was going to be receiving the injunction.
And how is that relevant to whether the injunction should be issued? Does it prove or assist in proving why the injunction should issue?
I guess not, sir.
The objection is sustained. Evidence 4 is not received.
Let me just... So he did receive the injunction in June. I believe it was June 31st or June 30th that he received the injunction. And he still continued making videos about me.
Objection, speculation, Your Honor.
I'll sustain it as a foundation objection.
Yes, sir.
Again, this is, ma'am, a statement. He continued to make videos about me. That doesn't give me any specific information. Does that mean that on June 22nd, 2022, you went on the internet and you observed a video, and on that video it said, this video was created by Mr. Dillard, and in that video there was a picture of you and that kind of information is helpful to me.
Okay.
But for you to simply make a representation that he continued to do something, when I don't have any personal information, knowledge of anything going on, is simply not helpful, and the objection is sustained on foundation grounds.
From May 21st to June 30th, when he was served, he had made over 77 videos and posts about me over 4 platforms.
Objection, Your Honor. Relevance.
Again, I'm going to sustain the objection on foundation grounds. Again, that's very generalized information. I don't have anything specific about any particular posting on any particular date by anyone. And so a statement that he made 500 posts or 1,000 posts or 10,000 posts really is no more helpful because I don't have specific information about anything. I don't have any information about any individual post. Do you understand what my concern is?
Yes. Okay, so going back to the week of May 21st to May 24th, when I realized that Mr. Dillard had started posting information about me, I ended up having to move out of my apartment because I was afraid that he would share my personal address.
Objection, speculation, Your Honor.
Sustained.
I ended up having to change my phone number because of the blocked phone call that I presume was from Mr.
Objection,
Dillard.
speculation, Your Honor.
Sustained. Ms. Winter, I'm going to try one more time. I need to receive specific information. That means dates, times, places, and circumstances that you personally perceived with one of your 7 senses. You need to tell me specifically what happened, when, and who was involved in that process. And that is not general statements about Mr. Dillard did this 50 times or Mr. Dillard did this 1,000 times. I don't know yet of any single instance of Mr. Dillard doing anything. And that's a big concern to me. Mm-hmm. So, again, I need to have specific evidence of specific conduct on specific dates at specific times with specific descriptions of what happened. And I can tell you that if it does not relate to something that happened before the stalking injunction was sought in the first place, it's not going to be very helpful to justify why it was issued in the first place.
I understand. So, on May 24th, Mr. Dillard had directed his followers to calling CPS on me.
Objection is cause for speculation.
Sustained.
I apologize. It was a really long time ago, May 21st to now, where we are now, and a lot has happened since then.
When was the original injunction issued?
It was issued and granted to me May 26th, and then he received it at the end of June.
All right. And so I need to know why you sought it in the first place. What specific events occurred that would justify a stalking injunction being issued? That's what I need to know.
Okay. So the specifics that I have written down are posting the address of my siblings.
Objection calls for speculation.
Well, that can be an introduction. Now that you've told me what the issue is, give me some facts about that so I can at least have some information.
On May 25th, he had posted that information by sharing my stepdad's sex offender registry information across his platforms.
Objection relevance.
Overruled.
Without knowing the situation or having anything to do with the situation, I believe that he did so posting the information.
Objection calls for speculation.
Sustained. What you think Mr. Dillard believed is speculative.
Okay.
You can testify as to what you saw, what you heard, but you can't testify as to what Mr. Dillard thought.
Let's see where I was. So my stepdad's background had nothing to do with the adoption situation. So I believe that this information was brought to light to bring harm to my reputation.
Objection relevance, speculation.
I'm going to again sustain the objection, but on foundation grounds. Ma'am, I have no idea who your relatives are.
Mm-hmm.
I have no idea when you may have interacted with your relatives. I have no idea why they would be involved in any discussions. And I have no idea what they saw or what they heard or what you saw or what you heard. And without that information, there's nothing I can do.
Okay. The second event that happened that made me want to have the injunction was the blocked phone call. It could have been from Mr. Dillard.
Overruled. There's no declaration or declarant in the statement that's been made.
Objection calls for speculation.
Overruled. You've testified that there was a blocked phone call.
Yes.
That's something that you would certainly know.
Yes.
So tell me about that.
So I was waiting for a phone call back from the police.
When did this happen?
On May 25th at 11:15 p.m.
Okay, so we're late in the evening on May 25th. Tell me what happened.
I had been waiting for a phone call back from the police after reporting that the address had been shared. And instead I received a blocked phone call from somebody who was...
You received a blocked phone call.
An unmarked phone call. No phone numbers were listed.
So you received a phone call.
Yes.
So your phone rang.
Yes.
But there was no number identifying
number.
where the phone call came from.
Correct.
Okay, tell me what else you know about it.
Well, Roy City Police Department, when they call you back, it's from a blocked phone number. So I answered assuming that it was the police. The person on the other end of the line...
Objection, foundation, and speculation.
Overruled. We do have foundation, finally. We know when. We know that this is an event that that Ms. Winter was personally involved in, and I'm trying to figure out what happened. So you received a call, had no number, you answered the phone. Then what happened?
I answered the phone, and I said, "Hello, is this the police officer?" And the person on the other end was not a police officer. All they said was, quote, "You and your father will pay for this."
Objection, hearsay.
Overruled. Hearsay, again, is a situation where the matter is offered to prove the truth of the matter asserted. In this case, the only relevance to that communication is that the words themselves were spoken. An individual can testify as to words that were spoken, and it's not hearsay. It's not being used to prove the truth of the matter asserted. Whether someone is going to pay for this, whether that's true or not, is not the point. But that is the only point that would be amenable to a hearsay objection. So it's only the fact that the words were spoken that is relevant, and that fact is relevant, and the objection is overruled. So continue, ma'am.
Immediately after hearing those words, the phone call was dropped. It just ended. And 2 minutes later, the Roy City police officer called me back, and I made him aware of what happened. He suggested that I change my phone number, and he and other officers began patrolling my area.
Okay.
At this point, I didn't...
This is all on the same evening?
Same evening, within about 5 minutes of each other. At this point, I did not feel safe even leaving where I was sitting in my home because I had no idea what was going to happen next, especially...
Speculation, foundation, relevance?
Overruled. It's the present sense impression derived from the phone call. She can testify as to how she felt. Objections overruled.
Especially after receiving that phone call with that phrase. So the next day, which was May 26th, was the day that I filed for the stalking injunction and left this information in the injunction, and it was granted hours later.
Okay.
And then we moved to trying to serve Mr. Dillard, which was the 2nd of June, and then him being out of town and getting the notification on June 23rd, and then finally receiving it on June 30th.
So he received the injunction, at least from your information, around June 30th.
Yes, so
Okay.
about a month later,
Okay.
which is how long it took me to figure out how to get it to him. I also know that the stalking injunction came with filing with the stalking injunction. I also had the personal conduct order and the no contact order in that. And
Right.
since he has been served, I believe that he has broken or violated both of those orders.
All right. This is not an enforcement action. This is an action to determine whether the injunction should issue.
Okay.
So that's the first question. If it's appropriate that the injunction be issued, then certainly that could lead to other things.
Okay.
If there is a question about whether the injunction should be enforced, that's not before the court today.
Okay. Excuse me. Because of the stress that I have encountered from the first week, as well as the month that it took me to be able to get Mr. Dillard served, I had ended up in the hospital.
Objection requires an expert witness.
What's the relevance?
The stress that I have endured because of all of this has put my unborn child at risk.
Objection, relevance, objection, opinion, and requires an expert witness.
Well, certainly the only issue that could potentially go to is the reasonableness of the apprehension. And what may have happened after the issuance of the stalking injunction cannot form the basis for its original issuance. So whatever happened after the stalking injunction was issued, or how you felt after the stalking injunction was issued, does not justify its issuance in the first place. I need to know why it should have issued in the first place.
I understand. Let me get the dates. So it was May 23rd, which was when I realized Mr. Dillard had been posting about me. The stress from that is what had put me in the hospital on May 23rd.
Objection, Your Honor, requires an expert witness and also a speculation.
The objection is overruled. Is your testimony that you went to the hospital on May 23rd?
Yes, sir, because
Okay.
I was feeling stressed.
All right. Thank you.
And I believe that is everything that I have.
So, you received, what was the date of that phone call again?
The date of the phone call was May 25th at 11:15 p.m.
May 26th. 5th.
2-5.
And what was the date that the original temporary stalking injunction was issued?
May 26th.
And it was on May 23rd that you went to the hospital?
Yes, sir.
So that was before the phone call
Before the phone call, yes.
and before the stalking injunction issued.
Yes. It was after the videos had been posted.
All right. Anything else? Do you have other witnesses that you are going to provide testimony from?
I do not.
All right. Thank you. Mr. Dillard, I'll hear from you.
Thank you, Your Honor. Firstly, on our phone conference on May 19th, I requested a motion to dismiss. You denied that motion. On the 19th, I also resubmitted another motion with your clerk of court to dismiss this case again. I would like to address that before we proceed, if that's okay with the court.
That's fine. Certainly your objection to the stalking injunction and request for a hearing contemplates that you are requesting its dismissal. So I certainly understand that. I believe what you're suggesting is that you're claiming that the court lacks jurisdiction to proceed.
That was one of them, the court, but then you explained that to me on the 19th about the jurisdiction of the court. So that's actually not my claim. My claim is that this entire petition just lacks foundation. Under Utah state law, you have to have two verifiable instances that proves that I stalked or harassed. Verifiable, meaning times, dates, names.
But before you get to this is the argument that will relate to the evidence that's presented. That is the substantive argument from the evidence. You're certainly welcome to present evidence if you wish, and I am going to hear argument after I know what the evidence is.
Okay.
And certainly you can make your argument when it's appropriate to make it. You're not required to put on evidence. If you want to simply argue the matter, I'm happy to hear argument.
Yes, I have no evidence.
Okay.
So I would just like to go right into my argument.
All right. Then, and certainly, as you may or may not understand, you have no burden of proof in this case. The burden is on the petitioner to establish a basis for the injunction. You have a right to present evidence if you wish, but you have no obligation to do so, and you can simply argue the matter if you prefer.
Yes, sir.
So if that's where we are, then we don't have any need for additional evidence, and I will then permit Ms. Winter to make her argument. All she's done at this point is presented evidence. And she does have a right, because she has the burden, to make the first argument. You can then respond to her argument, and then she will have an opportunity to reply to whatever argument you may make.
If I did not number the evidence the correct way, I cannot present it correct.
If you have evidence that you want to present, as long as you mark it before it's offered, I'm happy to consider it.
Yes, Your Honor. Can I have 1 moment, please?
Yes, you may.
Alrighty, Your Honor. It seems that I'm only going to have 2 pieces of evidence to submit today.
If you would then,
both for the petition.
if you have those, if you would just mark on a blank portion of each of those documents, the first one that you'd like to be considered R-1, and on the second one R-2, so that they can be properly identified. And do you have copies that you can provide to Ms. Winter?
I do. 1 moment. Okay, Becky. Just give me 1 moment to find the second one. So sorry, here it is. Yes, that's it. Thank you so much.
Thank you. So if you would like to present evidence, this would be the time to do that, Mr. Dillard.
Yes, Your Honor. Let me grab my copies.
Okay.
All right. So the two, R-1.
Make sure you're close to the microphone before you start to speak so we have a record. Okay, you may proceed. And again, to be clear, this is Mr. Dillard's presentation of evidence. It's not the argument, so you can present whatever evidence you wish. That includes any personal testimony. You are under oath. And if you want to present documents, describe the documents by their reference number, and we'll determine whether there's an objection to those documents.
Awesome. So, Your Honor, on or about May 25th, I was contacted by the petitioner. I was tagged on their video numerous of times. I'm actually a lived experience foster care advisor. I'm also a former foster youth, and I work closely with the CPS and adoption and foster systems throughout the country in different states. So when we have issues that come up online, like illegal adoptions, kidnapping, or any type of case where a child is in danger, I usually get brought into it just to investigate. So I was tagged on the petitioner's post by several people and asked to...
Describe what it means to be tagged on the petitioner's post.
So to be tagged means that another creator on TikTok went and how do you say this? They mention you. So when you get mentioned, oh, that's hard. I never had to explain TikTok. When they mention you, it alerts you. So like it literally makes a notification saying, hey,
your name shows up in a post that's been made by someone else.
And it alerts me that post
electronically, that name identification is picked up on TikTok, and you receive an indication that your name has shown up on a post made by someone else.
Exactly. And then people can click that name, which will take them back to my post or my page. So I was tagged or mentioned several times on the petitioner's page. I then watched the petitioner's video. It had, when I watched it, I think like 1.7 million views, at least 6,000 or 7,000 comments. It was very, 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 very viral. The petitioner was very...
What was the date of this?
That was May 25th, May 25th, or on or about. It might have been the 23rd or the 25th.
Okay.
As the petitioner says, this is months ago. So my exact dates are a little foggy as well, but on or around May 25th. The petitioner was very emotional in that video. My heart went out to her. I believe that she had lost a child, and I wanted to do my best to help her get her child back. I then wrote on the petitioner's page, I wrote a comment saying, I'm here if you want help. The petitioner then replied to my comment saying, yes.
All on the same day?
Yes, all on the same day. The petitioner replied to my comment and said, yes, I would love to go on live with you and get your advice on how to fix this. This is all the same day. So on May 25th, the petitioner came onto my live. We spoke about, I would say about 25 minutes. The petitioner explained the circumstances of their situation, of why they made the original video. I gave my professional advice by letting them know that I did believe that it was an illegal adoption that they had done, and that they needed to go through the court systems to make sure that everything was done correctly. Then at the end of our conversation, the petitioner asked me again if I would be willing to help her. I told her that I would help her and I would start investigations. My investigations, I usually run between 1 and 2 weeks, and I usually charge. So I told her I would do it pro bono for her because her original video it broke my heart. It really broke my heart. So I was going to do it for her for free because as a child who was in the foster care system and who was also adopted, that's something that's very personal to me, so that's why I do the work that I do. During my investigation over the next several days, so I believe on May 26th, I started my investigation. With my investigation, I usually do a deep background check when it comes to social media. I look at everyone involved in the case or the incident that Hope had, or that the petitioner had put on her original video. So during that investigation, I found several things that were just a red flag, that were public posts made by the petitioner. I found items of negligence for the child, and overall, the story wasn't matching up to what her original post had said. I offered for the petitioner to explain what the differences were, why were there so many discrepancies, and that's when her account just disappeared. Once I started asking questions like, were the courts involved? There was evidence that I got from the child's mother, Amina Fady. There was evidence that she was giving food stamps and WIC and governmental assistance to the petitioner, who the petitioner was using it. My understanding of Utah state law, and every law almost in the United States, it's illegal to transfer WIC. So once I started investigating, I started seeing the red flags. I started reporting on the red flags. And that's when the petitioner's account disappeared. After the petitioner's account disappeared...
When you say the petitioner's account disappeared, tell me what you mean.
So after I started asking questions about the authenticity of this adoption, and if it actually was an adoption, or if it was an illegal adoption or kidnapping, the petitioner's TikTok account completely removed it. And due to her testimony, she did say that she removed the TikTok account, I believe on May 26th, that same day that I started reporting. So then after that, let me get my thoughts together. So it's May 26th, the TikTok's gone. Okay, so I continued my investigation. I did make several videos, not naming anyone. I'm just speaking on the case. I was looking for the biological mother and the adoptive mother of the child in question, because at this moment I had no idea if there really was a child in question, if this story was even true, so I needed to investigate. Over the next several days, I believe on May 31st, I was reached out to by Amina Fady, who is the child in question's birth mother. She confirmed everything that I had been reporting on as far as the petitioner having some type of legal guardianship, but it wasn't through the court systems. She also confirmed that CPS in Ogden's sheriffs had removed the child from the petitioner's custody, and this was before the video was made. So that's why it's very important. That's why I'm bringing it up. The petitioner knew that she did not have rights to this child before she made that video on TikTok.
Objection. Speculation.
Sustained.
So when she made the video, she decided then to reach out to me like we had already discussed, and she asked for my help specifically. She never not asked me not to investigate. In fact, she asked me to investigate. It only turned sour, or I only became to harass her when the evidence wasn't favorable towards her.
Objection. Sorry, speculation.
What is the focus of your objection? What statement are you objecting to?
The statement where I was less favorable to him investigating because the evidence wasn't.
Okay, that would be speculative as to her motivation. You can certainly testify as to what your perception was, but not as to her motivation.
My perception of the petitioner's decisions to remove their TikTok was because my investigation was proving to be unfavorable for them. That is my perception.
Okay.
But moving on, because I do not want to waste the court's time, I would like to introduce the evidence. I don't remember if it is one or two, but it says it has the petitioner's name. It says bring Eli home, and this is one of hundreds of emails. It's that one. Okay,
that is a document. To identify it on the documents that have been submitted, it shows apparently a screenshot from a Verizon account with 7:09 p.m. In the center top of the screenshot. Is that the document you're referring to?
Yes, sir.
So that has been marked as R2. Ms. Winter, do you have any objection to the courts considering R2?
No.
Okay, R2 is received.
Alrighty, Your Honor. So in this piece of evidence that we see here, I'm going to read it aloud for the court. It says, "This is one of hundreds of emails, messages, DMs, and conversations I've received since going viral. There are multiple TikTok creators with huge followings sending followers my way. I'm upset enough without having Eli, and that isn't enough for others. They want me dead. I am trying to be strong enough through their madness, and people are hiding behind their screens. I'm not a trafficker. I'm a mother." Now, unfortunately, we don't have an exact date on that post, but I do believe that it was made on May 28th. My issue with this is that here in her own words, the petitioner says that she's had multiple TikTok creators with huge followings sending people her way. She also says that she's upset about going viral. So the issue here is we understand that there was a video that had millions and millions of views, and the petitioner's own words, there are multiple creators, including myself, but multiple creators on TikTok who've reached out to her with huge followings. So the idea that I personally caused any type of stalking, harassment, or harm specifically to me has never been proven, nor does she even state that. And even in her initial claim on the injunction, in her initial claim in the injunction, she says the same thing she said here. She said there are people online who are coming. She never actually said that I did anything to her specifically. So I want to just go back to this piece of evidence. To me, I feel like this clearly states that there's multiple TikTok creators. So I'm very confused at how everything is my fault when we know that there are multiple people who are addressing you, and how that all of her emotions that she felt that day are my fault. Like she clearly says, she's upset that multiple people were coming after her and sent their followers. And even in her own testimony earlier today in the court, she said that she went to the hospital after that. But how can you say that that was me when multiple TikTok creators were coming after you and sending their followers?
Yeah, I don't want to hear the argument now. I'm just hearing facts.
Yes, Your Honor. I'm sorry about that. That's all I have for this part of this evidence. The other part that I would like to speak on the factual basis of this case, give me one moment. I understand that sometimes TikTok can be a place, it can be rough, and it can be a place that, it's virtual and no one really it's new. But when you specifically ask, like in her original video, she said, "TikTok, do your thing and help me." And then she additionally asked me for additional help on my live. The petitioner essentially asked me to investigate. So I want to end my piece. Or actually, no, I want to bring this last piece up. If the court can bring up evidence R1, please.
I have R1, and for identification, it's been marked, again, as a screenshot. In the upper left-hand corner, it shows a timestamp of 10:07. So I think that's sufficient to identify the individual sheet. Is that correct?
Yes, Your Honor.
All right. Any objection, Ms. Winter, to the introduction of R1? Okay, R1 is likewise received. You may proceed.
Thank you, Your Honor. I would like just to read out this part. Bo Winter, I believe that this post was made on or around May 28th. Bo Winter is the petitioner's biological father. In her claim, the petitioner says that she was the one being stalked and she was the one that was having anxiety and being harassed. But clearly here, you can see that it says also, because of all the hatred we are getting from the live videos, the real Carlos Dillard, that was one of my TikTok accounts, who is obviously extremely uneducated. We're going to an admin-approved comments only. Try to hate, get booted. Too many of you are driving my daughter into a deep depression, and that's what I wanted to emphasize on. Even her own father sees that there are multiple creators who are causing this uncomfortability for the petitioner, and my heart goes out to them as a mother and as a human being. But the fact of the matter of the case is, I am not responsible for this for her feelings when there are multiple people. And she also it also goes into say that she was going into a deep depression. And for those who are helping us, thank you. At that moment, I thought I was the one helping because the petitioner came to me and asked me for help. But clearly, from her father's own words, she thinks I'm hindering her instead of helping. So I was very confused when I saw this because I was specifically asked to help and to help investigate. And I want to emphasize the word investigate. The petitioner asked me to help investigate. And my investigations, I don't just look at one side. I'm not an attorney. I'm an investigator. I'm an investigative journalist for illegal adoptions and kidnappings. I have to investigate both parties. So I investigate Hope. I investigated Amina. I investigated the new adoptive parents. So I just wanted to make that clear on this piece of the evidence that even in her own words on the first piece of evidence and then on her father's words, they both know that there are multiple people who were investigating or sharing the story. And I think that that's the end of my evidentiary part of this, and I would like to move on to argument.
All right. Thank you. So R1 and R2 have been received, and Ms. Winter, I will hear your argument. In your argument, what I need to understand is what you are requesting that the court do today and why you think it should be done. And you can make reference to any of the evidence that's been presented.
Today I am asking that the court grant the stalking injunction, not only because of the evidence that I have provided, but because now that Mr. Dillard has had the stalking injunction since June 30th, things have still been escalating to the point where Mr. Dillard even directly mailed me an article.
Your Honor, I have to objection. That was court documents. I mailed her court documents.
Well, this is argument. It's not the time for presentation of additional evidence. So the opportunity to present evidence has already occurred, and I'm not hearing additional evidence.
You have the copy of the shipping label that I provided to you.
Was that offered in evidence?
Yes, it was.
But you didn't.
When was it offered in evidence?
When the stack was handed to you.
That's. In order for something to be considered as evidence, you have to actually refer to it while you're making the
okay, that makes
presentation.
Sense. Okay. So scratching that part, I would like the stalking injunction, I guess, granted to me, as well as I wrote them down, as well as the personal contact order and the no contact order, simply because at this point I no longer feel safe. As I had mentioned before, I went through a period during all of this where I did not feel safe leaving my home. I didn't feel safe sitting in my home. I changed my phone number. I can't even babysit the children that I was babysitting before because they don't feel safe because of the accusations made about me. So really I just want the injunction granted to me so that I can move on, so that I can actually feel safe walking around. I understand that Mr. Dillard does not live in Utah. He lives out of state, but he has followers that live in Utah. He has contacts that live in Utah, and they are capable of finding me because now Mr. Dillard has my address.
Okay. Anything else?
I had written down that I still receive negative repercussions from the videos made months ago, and I was requesting that any video or post be made about me through his account be taken down because of the repercussions that I still face today. But thinking about this, I don't think that would even help at this point, so I think that is everything.
All right, thank you. Mr. Dillard, I'll hear your closing argument.
Thank you, Your Honor. Your Honor, thank you for taking the time to hear this case today. Unfortunately, the circumstances surrounding this case are really sad, which include the petitioner attempting to illegally kidnap the baby of Amina Fady. The petitioner in this case reached out to me initially on May 25th via TikTok to help her get Amina's baby back to her. The petitioner subsequently had a video go viral on TikTok requesting for the TikTok universe to help her. She requested thousands of dollars from the general public via her viral TikTok video, which amassed millions of followers and views and thousands of dollars to help her achieve this goal. The petitioner wanted me to help her due to my notoriety within the adoption and foster care community. I had spoken to the petitioner over the course of several days when things began to look a little fishy. I was among many others who had quickly discovered that the baby in question was legally and forcefully removed from the care of the petitioner by the way of Child Protective Services and the Ogden Sheriff. During this encounter, the petitioner had grabbed the baby and ran. When the sheriff ultimately apprehended the petitioner and successfully
Again, Mr. Dillard, same caution. This is not an opportunity to present evidence.
Yes, Your Honor.
Those facts are not before the court, and so they're not to be addressed.
Yes, Your Honor. Okay. Thank you for clarifying that. I will move forward. I would just like to say sometimes TikTok can be rough, and it can be a rough place, especially when you lie to millions of people. But in the case that was presented before you today, the petitioner makes several claims that cannot be attributed to me. Like we saw in the evidence, she herself said that there were hundreds, maybe thousands, and millions of people who saw that video, and many creators who were calling her out or sending, quote, their followers after them. In fact, she didn't even attribute them to me at all. She just seems to attempt to impede my constitutional right to free speech, freedom to the press, as I am a journalist and a published author, as well as my personal right to due process. In a frantic attempt to prevent me from speaking out about an illegal adoption and kidnapping attempt she made against Amina Fady, the biological mother, the petitioner lied, committed perjury, and obtained this injunction. I have never threatened her, attempted in any way to harm her physically, emotionally, mentally, or financially. I understand that it must be really difficult for her to face the reality that she illegally took advantage of Amina Fady, and to recognize that a lot of people on TikTok were really upset with her and unwilling to financially contribute to her anymore. But that does not fall onto me. I get it. The petitioner doesn't like me. And in full transparency, the feeling is neutral. But there is no way, this in no way rises to the level of a stalking injunction or harassment. I did nothing wrong. And I believe that the testimony that you heard today will show that. Lastly, I would like to say that this has been very, very financially straining for me and my family. As the petitioner already said, I don't live here. I had to take 3 planes to get here. My husband had to come with me. All of these out-of-pocket costs that I've incurred simply trying to help the petitioner because they asked me to help initially. Not only is that, but I've had 2 of my accounts taken down by the petitioner and her family. They said it out loud. They just said, like, we got your accounts taken down. They've been actively actually harassing me.
Again, I'm not hearing additional evidence.
Okay, I'm sorry, Your Honor. So lastly, I would like to just end it with saying, how am I responsible for a viral video about something that happened to the petitioner when she self-admittedly had millions of people watch it, hundreds of creators try to help or hinder her, and she actually has not proven to me or the court today of the 2 instances that I attempted to stalk and harass. According to Utah state law, you have to have verifiable instances, like actual dates, times, what I was wearing, or even the phone call. She said there was a phone call. Was my voice on the phone call? Was it me on the phone call? Did it come from my state? I have not seen any ounce of evidence that any of this was actually me, and I don't think that she has proven any of this because of her own words. There were thousands of people, millions of people who saw the video who were upset. So, Your Honor, I will ask that the court dismiss this entire injunction. It is causing my professional life harm. Because of this injunction, I've had to halt all of my mentoring with foster youth, which is actually hurting my mentees. I mentor foster youth who are about to age out and prepare them to go into the real world and teach them financial literacy and how to be, a functioning adult. I've had to pause those due to this motion because the agency that I work with, they're very particular about having any type of harassing or stalking or any type of litigations against a person working for this agency. Also, like I said earlier, 2 of my accounts have been permanently banned because of the mass reporting, specifically from the petitioner and her family, and they told me that they did it themselves. So this whole thing started out me trying to help a person because I felt really bad for her. Because she lost a child, and I was one of those lost kids. But it turned out that child wasn't lost, that child was stolen. And when I was trying to report the story, she's using the court to silence my First Amendment right and my right to freedom of press as a journalist. So I'm asking the court to do the honorable thing and to dismiss this because there's been no reasonable explanation or evidence that I did any of the things that she claimed in her initial injunction. That's all I have, Your Honor.
All right, thank you. The matter that's actually before the court today is a request for a permanent stalking injunction. What has been presented to the court today is perhaps best described as the awesome, and I mean that word by its literal meaning, the awesome power of the Internet to impact and at times interfere with the lives of those who choose to participate in social media, on the Internet. There is no requirement that lives be lived on the Internet. There is no requirement that people have social media accounts. But when people choose to live their lives on the Internet or to engage in social media accounts, they make themselves available to whatever reactions and responses may come from an indefinable universe of individuals, some well-meaning, some perhaps very ill-meaning. And there is no control over those initial reactions. That is in its very nature the awesome, and again I use the word in its technical sense, that is, it is enormous, and its power is perhaps incalculable. Its reach can never be fully defined, and the impact of something being placed on the Internet can never be fully anticipated and can never be fully retracted. It is a circumstance that when individuals choose to participate and to a substantial degree live their lives on the Internet, they're subjecting themselves to whatever the Internet may bring. Now, that doesn't mean that all conduct on the Internet is appropriate. It does not mean that all reactions or responses that flow to a post on the Internet are appropriate. And it also does not mean that an individual inappropriately using the Internet to harass or intimidate or harm someone else is shielded simply because of the Internet. The Internet is not a general license to harass. It is not a general license to demean or defame. It is not a license to intimidate or to impose harm or to foster anger or hatred or anything else. It is simply a means of communication. And it is the individuals using the Internet that choose to use it either for positive or for negative means that convert the Internet to a mechanism which can do a tremendous amount of good, but an equally tremendous amount of evil. And those who choose to unleash the power of the Internet by posting videos or making comments, do so with the necessary understanding that they, by that choice, substantially lose control over the reaction to that content. And that is really the circumstance that's been presented to the court today. In order for a stalking injunction to issue, the legal requirements for a stalking injunction are essentially that the party seeking the stalking injunction is required to show that a particular person has engaged in a course of conduct directed to the party seeking relief that would cause a reasonable person to be apprehensive or fearful or feel at risk. And that course of conduct must be evidenced by at least 2 specific instances of conduct which are consistent with that definition. In this case, notwithstanding numerous requests and urgings by the court has received only the description of one instance that could be characterized as a stalking event. This was a telephone call. There is evidence that a telephone call was placed to the petitioner at a particular time on a particular date in May of 2022, that the phone number was not displayed and not identified in that call, and that an individual making that call made a statement which could be perceived to be threatening to the petitioner and to her family. However, the evidence is insufficient to attribute that phone call to the respondent in this case. There is no evidence that the phone number, which was not displayed, was somehow determined and attributed to the respondent. There is no indication that the caller identified themselves or provided any identifying information that could be connected to the respondent. And given the testimony that there were not only several, but perhaps thousands of people that may have had access to information which could have prompted such a call, the court finds that the petitioner has not established by a preponderance of the evidence that this particular incident is attributable to the respondent. So the court cannot find that this is an incident of stalking that would be chargeable to the respondent in this case. And even though there have been numerous statements about hundreds or even thousands of reactions to posts being placed on the Internet, there is no specific information that those can be traced to a course of conduct originating from the respondent and directed at the petitioner. Certainly it appears that there have been numerous reactions to the petitioner, perhaps some positive, perhaps many negative. Those have been simply characterized in very general terms to the court, but not in the specific terms that permit the court to make a connection between the petitioner and the respondent. It does appear that there was interaction between the petitioner and the respondent. It does appear that that interaction had to do with the placement and or adoption of a child. That does not appear to be disputed between the two parties. Beyond that, the court can make no findings. For example, there have been references by the respondent that the petitioner was involved in an illegal adoption. The court cannot make any such finding. And to suggest illegal conduct by someone else or to attribute illegal conduct to someone else is a highly questionable practice. And I would caution the respondent to be very careful about the way you make characterizations. Characterizations using similar terms on the Internet are not shielded or protected. If allegations are made that someone is involved in illegal conduct or activity, that may very well form the basis of a defamation action, which could be very costly. And so I caution the very careful use of any kind of references to illegal or improper conduct. The consequences of that, when placed on the Internet, may be similar to the consequences of other things and may be beyond the party's control from what they originally intended. But nonetheless, it's pretty tough to put all the down back in the pillow once it's been spread, and it's very difficult to unring the bell. So I caution both parties about the kinds of conduct and the kinds of comments that may be made in the heat of the moment or based upon a particular perception, which is not appropriate. I also caution the respondent, the suggestion of illegal conduct or that someone may be prosecuted for something goes beyond the realm that a private citizen can engage in. Prosecution for crimes is exclusively the domain of prosecuting authorities. Private citizens do not have either the right or the ability to threaten criminal prosecution or to suggest that it's appropriate. I'm making my ruling, sir. I'm not going to hear anything else. I've heard from both parties, and now you're going to have to hear from me. So I'm simply cautioning both parties with respect to the types of conduct and communications that have occurred. Simply waiving the First Amendment and saying I have the right to say anything I want is simply not true. There are limits to the First Amendment. And the First Amendment does not protect all comments of all kinds in all places. And anyone engaged to any substantial degree in the Internet needs to proceed with substantial caution rather than simply waiving the First Amendment as a justification for conduct which may be questionable. And again, I'm making no ruling today that the conduct of anyone has been illegal or inappropriate in this case, and I'm not making any findings that there has been any illegal conduct. Notwithstanding the perceptions of the parties with respect to how the other may have acted in this case, the court makes no finding on any of those issues. I just caution both parties that hopefully you will learn a lesson from this proceeding that can be avoided by being a little more circumspect in the way you deal with matters on the Internet in the future. That having been said, and making no findings on those issues, the court finds that the legal basis for the granting of a stalking injunction in this case has not been established. There have not been sufficient instances establishing by a preponderance of the evidence a course of conduct being directed by the defendant against the petitioner which a reasonable person would perceive as being threatening, harassing, intimidating. There's no evidence of surveillance. There's no evidence of proximity that would cause an individual to be fearful for one's safety based upon being followed or photographed or surveilled or anything of that kind. This is a circumstance which obviously got out of control and for which everybody involved in the Internet bears some responsibility. But that shared responsibility may be among hundreds, thousands, millions of people. The court can't make that determination. But the only determination which the court is permitted to make in this case is whether a course of conduct defined within the parameters of stalking exists and being directed by the respondent against the petitioner, and that the court cannot find in this case. Accordingly, the stalking injunction, the temporary stalking injunction that was previously issued, is terminated, and no permanent stalking injunction will issue. Perhaps I could suggest to the petitioner that if you're fearful about the consequences of being involved in social media on the Internet, that may be a circumstance that you may want to avoid. It is possible not to engage in social media. And if the peace of your life requires your not being involved in social media, so be it. And that may be a recommended course of conduct. But once you unleash the whirlwind, it becomes rather difficult to attempt to contain the consequences. So the stalking injunction will not issue in this case. Do we have a denial document? Stalking injunctions, as you may be aware from the documents that have been prepared already, are by law in the state of Utah conducted and handled on very specific documents. The documents themselves are forms that the court is required to use. A request for stalking injunction is a specific form that must be submitted to obtain it. The initial temporary stalking injunction is a form that's defined by law and must be used by the court in the issuance of that injunction. It's not something that the court simply freeforms or drafts at will. The same is true with respect to the termination of a stalking injunction. There is a denial order, which is a specific form which the court is required to use, and we'll locate such a form and complete it in this case, and the parties will each receive a copy of that document before you leave today so that can be completed. Do you have one? Do you know, ma'am, whether the complete packet of documents were submitted when the stalking injunction was issued in this case? Many times the packet will include the alternate documents, the temporary order, the permanent order, the denial order. All of those are frequently included in the entire packet that's submitted. Do you know whether those were all submitted in this case?
I've never seen the denial part, just the last two.
Your Honor, after you make your decision, may I address the court one last time?
Hold on just a moment. It's actually, this is the one that's used for the original ex parte request. Then there's one that refers to the hearing. It could be disorder of dismissal or identifies who is present. See if there is a dismissal form document. Yes, that is the one. Thank you. Do you have the file up? I just need the date that the temporary order was issued. Okay. All right, I have now completed and signed the order dismissing the stalking injunction. So the temporary injunction that was issued on May 26, 2022 is dismissed, and no stalking injunction will issue in the case. I have signed that order. Each of the parties will need to also sign their acknowledgement that they have received a copy. Then the bailiff will prepare copies so that everyone's confirmation of having received the document will be provided before you leave. Are there any questions or other issues to be addressed? Mr. Dillard.
Yes, Your Honor. According to 78B, Chapter 7, Part 7, Section 701, Number 14, it states, after hearing with the notice to the affected party, the court may enter an order requiring any party to pay the cost of the action, including reasonable attorney fees. In my request to dismiss, I did put the petitioner on notice that I intend to seek costs associated with me being here, being forced to come to Utah today. The total costs are roughly $700. I have the receipts printed here for my flight and hotel. I would ask the court to award me these fees required to attend this hearing in the amount of $700 or whatever the court determines to be reasonable for this case.
All right. Ms. Winter, do you want to respond to that?
I would like to. I didn't request the hearing. I don't feel I should be responsible for the cost if I'm not the one that requested the hearing. On top of that, I actually just said I didn't request the hearing. That's all.
All right. Anything else, Mr. Dillard?
Yes. Just because she didn't request the hearing, she initialized this entire thing by going and getting the stalking injunction, by not dismissing it or dropping it the last 4 months, and then by making me financially come out here. It is her responsibility. The court has proven that I did not stalk her or harass her, so why am I here? Someone needs to be held responsible for my time, money, and energy spent on this frivolous case.
All right. I'll rule on the issue. The specific statute that's referred to permits the court, and it uses the word may, not the word shall, award attorney's fees and costs. First, there are no attorney's fees to award. Neither party is represented by counsel, so no attorney's fees may be awarded. The second is the definition of cost. By definition, costs include costs that are required to be paid to the court. Those are such things as filing fees or witness fees, or other costs that the court requires to be paid. The court has not received any indication of any required cost incurred by anyone in this case. There was a filing fee, I believe, that was incurred originally by the petitioner, which she will not be able to recover. And I'm not aware of any, quote, costs within that definition that have been incurred by the respondent. Transportation costs are outside of that definition. Similarly, this will be an example. When an attorney requests reimbursement for fees and costs, even though he may have a secretary that he pays a salary to and had to pay that secretary thousands of dollars to prepare a particular case, that's not a cost that can be recovered in a court action. That's simply a cost of his doing business. The mileage that he uses to drive to the court or to fly to the court is not a recoverable cost. That is simply a cost of doing business, not a cost of the court action. And so the ruling of the court in this case, although there have been expenses incurred, they do not meet the definition of chargeable costs. That perhaps is further motivation to be very, very careful about the types of interaction that one engages in to avoid being caught into a situation that may very well result in legal actions being pursued. But at this point, the court finds that there has not been any indication of an appropriate either attorney's fee or chargeable cost that may be awarded. So the request for the reimbursement of transportation the court rules is outside the definition of costs and therefore not awardable. So the request for that award is denied.
Thank you, Your Honor. I appreciate that explanation.
And again, I hope both of you listen carefully to the cautions of the court. The discussion about the necessity of evidentiary proceedings and appearances in court are taken very seriously by the court. We do not live in an exclusively virtual world. And when proceedings occur in court and evidence is to be presented in court, the court expects that the parties will be here to present that evidence. We've already had that discussion, and both parties, to a very substantial satisfaction of the court, did exactly that. This could not have been accomplished virtually in the same way that it was accomplished with the parties actually here. And that's just a caution. There is a real world. The universe is not entirely virtual. And personal responsibility extends into that real world. And real world actions have real world consequences. And that includes expenses, it includes inconvenience, and it may include the requirement to appear just as you have appeared today in order for rights and issues to be appropriately determined by a court. And that's what has happened today. This matter has now been concluded, but that is simply a caution that the entire world cannot be lived behind a screen. And a screen does not shield one from the responsibility of personally being involved when matters in which an individual is involved become the subject of litigation. That has been evidenced today, and I hope both parties have learned a little bit of a lesson from that. So there's just a caution on going forward. There is a real world out there, and it has consequences just like the virtual world may have consequences. So consider that as you engage in whatever other choice engagements you choose to make in the future. But that will conclude our proceedings for today, and we are adjourned. And again, I thank both parties, and I commend both parties for the civil and professional tone of the discussion and presentation today. That is admirable. And that's the way disputes should be addressed and resolved. It is civilly, it is by logical presentation, it is by argument, it is by evidence. It is not by emotion and by threats and intimidation. That too often occurs on the Internet, and that's unfortunate. But when it's in court, it is expected to be professional and appropriate. And in this case, I can commend both parties for having been appropriate and professional, and I thank you for that. So that will conclude our proceedings for today.
Thank you, Your Honor.
Thank you. I know the exhibits will be retained.